Call the second case on this morning's docket. Case number 115286, State of Kansas v. Kyle Chavez Majors.
Good morning, I'm Rick Kittle. I represent the appellant, Mr. Chavez Majors, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Factually, in this case, on the date in question, a park ranger named Burt was dispatched to a state park in Butler County, report of a traffic accident. When he got there, about 10 minutes later, he investigated and he found out that Mr. Chavez Majors had ridden a motorcycle into this parking lot, lost control of it. The motorcycle tipped over and slid, and as it slid into a parked car, it also struck a woman who was injured. The park ranger, Burt, went to check on Mr. Chavez Majors. He saw blood on Mr. Chavez Majors' head, and he bent down to check on Mr. Chavez Majors' breathing. He was unconscious, and Burt detected alcohol on Mr. Chavez Majors' breath. EMS was summoned. They were going to transport Mr. Chavez Majors to a hospital in Wichita. Burt read an implied consent form to Chavez Majors, who was still unconscious, and then directed the EMTs to take a blood draw from Mr. Chavez Majors, and that's the evidence that's at issue in this case. Mr. Chavez Majors was convicted of aggravated battery while driving under the influence of alcohol at the district court level. The main issue litigated was a suppression issue, which lost in the district court. The matter was appealed to the Kansas Court of Appeals, which overturned Mr. Chavez Majors' convictions based upon the failure to properly obtain a waiver of the trial right, a jury trial right, but affirmed the district court on the suppression issue, and the suppression issue is what comes to this court on petition for review. A couple weeks ago, 3 weeks ago, this court issued an order directing the parties to address the recent United States Supreme Court of Mitchell versus Wisconsin and whether it has application here. Mitchell held that the exigent circumstances exception to the warrant requirement almost always permits a warrantless blood draw when the driver is suspected of drunk driving and is unconscious and therefore cannot submit to a breath test. The plurality in the Mitchell case spent a great deal of time talking about how blood alcohol concentration begins to dissipate almost immediately after the person is taking their last drink. However, that fact alone does not bring blood testing within the exigency exception to the warrant requirement, and that's where the case of Mitchell addressed unconsciousness. And I would argue that Mitchell versus Wisconsin does not apply in this case for multiple reasons.
Before you get there, can we talk about whether there was probable cause or not? Because we don't get there if there was not probable cause to make an arrest or probable cause in this instance. And there's kind of I don't know if there's a line between reasonable suspicion and probable cause, but are you contesting that there was probable cause?
Well, that's one of the issues that was raised below, and we were claiming there was not probable cause in this case because one of the main state's issues, state's witnesses whose name was McElhone, testified that he had observed Mr. Chavez Majors earlier that evening drinking alcohol, but for whatever reason, he didn't believe that Mr. Chavez Majors was so intoxicated that he couldn't safely drive the automobile. And also, I think there was testimony from Burt himself, who acknowledged that even though he smelled alcohol on Chavez Majors' breath, that doesn't necessarily mean that he was intoxicated to a level that he wouldn't have been able to safely drive the motorcycle.
Well, you would concede there's reasonable suspicion.
I'm not disputing that, no.
How much, and it seems to me there are several factors to consider whether there was probable cause, and that is the excessive speed that Bert understood by talking with the witness, the accident itself, and the odor of alcohol.
Right.
And then they talked about I think both the Court of Appeals and the District Court talked about the location, the party cove, or for lack, and that entered into the calculus.
Right.
Does all of that equate? Is the location relevant in that determination?
I didn't quite understand what the courts were referring to. I think what they were mentioning was the fact this happened at this location where people typically gathered and
There's
drank
beer,
alcohol.
there are beer cans in the place. Does that
Right.
factor into the determination?
I don't think it factors into the determination of whether there was probable cause with respect to this individual. I'm not sure. There could have been people there at the party cove who had nothing to drink at all. So, and that same fact applies when you're considering some of the statements of Bert that just because there was an accident, just because the man lost control of the motorcycle, accidents happen all the time. Traffic accidents happen all the time when there is no alcohol involved. So those facts alone don't make it an imperative that this man must have been under the influence of alcohol. And even when you combine all those things, I would argue that there was not information rising to the level of probable cause in this case.
I just wanted to get and you're about to address Mitchell, but explain to us why Mitchell wouldn't apply. What wasn't your client unconscious?
He was.
At the time, there was odor of alcohol.
He was.
Doesn't this circumstance directly addressed by Mitchell? I don't see where it isn't.
I
So
think
tell us why it isn't.
what Mitchell actually says, it doesn't give a blanket
Almost
statement. It says almost always, which I find was a little peculiar language to use, but it leaves room. And I think it uses that language because it wants to account for situations where, because of the particular facts of the case or the particular law that might be applied, would bring a case out from under the exigency exception.
And how does your case fit in that hole?
First of all, Mitchell, I think, recognizes that under the exigent circumstances exception to the warrant requirement, a warrantless search is allowed when there is a compelling need for official action and there's not time to get a warrant. And I think that's still the law after Mitchell. So look at those factors. First of all, I contend that the facts produced at the suppression hearing indicate that there was, in fact, time to get a warrant. Bert, by his own admission, could have had the paperwork done for a warrant application within 1.5 to 2 hours, which leaves sufficient time to get a warrant within 3 hours, and that's the 3-hour period Bert was talking about, I assume was based upon the statute under which Mr. Chavez Majors was charged, which is 1567A2, which says a person is guilty of DUI if their blood or breath concentration of alcohol is 0.08 or greater within 3 hours after the last time they were driving a vehicle. So Bert, by his own admission, could have gotten this done within 3 hours.
What about the Supreme Court statement that says enforcement of BAC limits, which requires prompt testing, because it is a biological certainty that alcohol dissipates from the bloodstream at a rate of 0.01% to 0.025% per hour?
Well, that's the other point I would make here. Chavez Majors was charged under subsection A2 of the statute, the DUI statute. Subsection A1 provides another form of DUI, which says that DUI is operating or attempting to operate a vehicle when the concentration of alcohol in a person's blood or breath is 0.08 or greater, as shown by any competent evidence. So there is a form of DUI on the Kansas statute books which requires proof of a certain blood or breath alcohol concentration, but does not impose any type of time constraints. So in this case,
it just seems to be Mitchell took time constraints out of the picture here. And again, back up for me. Why isn't that right? Mitchell just looks at the exigent circumstances caused by the accident, unconsciousness, and it almost forces the officer, as they say, to perform kind of a triage. You got to look at all these things, and the officer can't focus necessarily on the warrant requirement, and this creates the exigency that Mitchell addresses. And it further carves the exception to expand to the condition of the person that you're seeking the blood draw.
Let me answer that by talking about Bert for a second, the law enforcement officer here. Bert had been a park ranger for 5 years. By his own testimony, he had been trained in the application for search warrants, but he had never had occasion to do that. There's a telling bit of exchange in his testimony at the suppression hearing, which I think helps to bring this case out from under the application of Mitchell v. Wisconsin. And here's the exchange. Question of Bert. Question, did you even consider the possibility that you might need to obtain a warrant? Answer, no, I did not. Question, so you made no attempt and no consideration as to whether or not when you're conducting a search you're going to obtain a warrant? Answer, not on this occasion, no. Question, you didn't try to get a warrant? Answer, no. Question, any reason for that? Answer, no, sir, I don't. That's at page 24 of volume 2 of the record. Bert, by his own admission, never even considered getting a warrant in this case. My point would be, how can this be a case based upon exigencies and time constraints and unconsciousness when Bert was Bert was not considering the pros and cons of what he needed to do, how he was going to get a warrant, whether he had time to do that, whether he needed to order a blood draw. Because by his own admission, he never considered that at all. If he didn't consider getting a warrant, he's not considering any of these exigencies. But the other point is, by his own testimony at trial, he had time to get a warrant. And if the law still applies that says if you have time to get a warrant, you still should, then he should have gotten a warrant. The other point is, Kansas law makes it possible to charge someone with a crime of DUI by proving a blood alcohol concentration even without any time constraints. That's what subsection A is. So in this case, even if the blood had been drawn 4 hours after the last time he was driving the motorcycle, that evidence, that blood draw evidence, could have been used against him. Now, the state may have had to produce other evidence to show that, well, if his blood alcohol level was at this level 4 hours after the accident, 3 hours after the accident, it would have been here. But the point is, Kansas has this statute on its books, which makes it much less compelling that there are time constraints or considerations about unconsciousness when a person can be charged with a certain level of blood alcohol, even if the blood is taken after the 3 hour
Is the
time
argument then there is no exigent circumstances given that?
Yes, I think there is. At the very least, it makes it much less compelling in Kansas that there is a need to draw blood within 3 hours, because you can charge someone with having a blood alcohol level of 0.08 or greater, even if the blood alcohol is taken after the 3 hour time period.
Does the fact that he was being taken by ambulance to the hospital become an exigent circumstance where there would be IV fluids, potentially other medical treatments that might change the blood draw?
Your Honor, that might be. I don't know.
I think the Supreme Court has talked about that in prior cases, at least McNeely.
But I think the fact that overrides that is that Bert admitted in this case, and that's the reason why I think the almost always language is used by the United States Supreme Court. Bert, in this case, never even considered those types of things.
Does that matter? Is this a subjective test or an objective test?
Well, I'm not sure about that, but what I would say is that the state has the burden of producing evidence to convince the court that the officer acted within the law. And the state produced, this evidence here indicates that Bert wasn't taking these matters into consideration of a warrant at all. And so the state hasn't produced enough evidence to show that there are actual exigencies that applied in this case, certainly not that Bert ever considered.
Counsel, I don't understand your argument about the
the .08 not having any time. I mean, I understand what you're saying, but I don't understand why why exigent circumstances isn't an issue, because the state could pursue a lower level of a crime. Can't the state pursue the most serious level of whatever crime is presented, and that's the exigent circumstance bar? They don't have to settle for a lower crime.
Your Honor, I'm not saying that he should have been charged under a different subsection of the statute. I'm just saying they could have used the blood alcohol evidence even though they charged him under subsection.
So what? Because why can't they just figure out what the crime is now, rather than, well, okay, maybe if we let it dissipate, it'll go to a lower level of crime. But it seems like you're saying that they have to give up a more aggravated level of the crime.
What I'm saying, well, even if we assume, and I'm not disputing this fact, that blood alcohol concentration begins to dissipate very quickly after someone has taken their last drink. Even if that's correct, the evidence in this case, even if the blood alcohol had been drawn with a warrant 5 hours after the accident, that evidence still could have been used to prove the crime as it was charged in this case, because the state could have produced evidence regarding, how much, if the blood alcohol level is this 5 hours after, how much would it have been 3 hours after? There's a case called State versus Silva, a Kansas Court of Appeals case, which I cited in my brief and in the petition for review, which indicates that, that type of evidence can be used regardless of whether the blood is drawn 3 hours later, 4 hours later, 5 hours later. It can be used to prove the defendant's blood alcohol concentration at a point, I think it was 2 hours in the Silva case. That was what the law said back then. So for all of those reasons, this is not a case, almost always is the key here. It's not an absolute. And in this case, there are factual peculiarities about the case, and there is Kansas statutory law that exists, which makes those matters of unconsciousness, of time constraints, much less compelling as exigencies that it should apply here. And don't forget the fact that Burt admitted he could have got this paperwork done within the 3 hours. So the state hasn't really shown that they couldn't get this done within 3 hours. My time is up, so I entertain questions the court might have.
Any more questions?
I'm still confused by this time argument. If you are driving under the influence, if you're 0.8 or above, and there's this 3 hour time differential, and we know that the alcohol metabolizes at a certain rate. What you're saying is, it sounds to me like you're saying, well, first off, the officer doesn't know what his blood alcohol is until he takes it. He doesn't know whether at the time of the accident he's 0.09 or 0.9, 0.09 I guess it is, and that it will dissipate to below a chargeable level if he waits, as opposed to knowing that it's substantially higher, and if he waits and gets the blood alcohol within that 3 hour period, he's still going to be above the intoxication level.
Okay, let me try to answer your question like this. Suppose this had happened, and the blood alcohol had been drawn 4 hours after the accident. And 4 hours after the accident, the blood alcohol had been 0.20. From that, you could reasonably conclude that 3 hours after the accident, the blood alcohol concentration would have been even higher. Right. Okay? But if the blood had been drawn 4 hours after the accident and it was at a point of, say, 0.06, you can still extrapolate back to 3 hours prior to that to see if the blood alcohol would have been higher, which it would have been, and if it would have been over the 0.08 level. So that's why blood draw evidence can be used to prove the crime that was charged in this case, regardless of whether the blood was drawn prior to or after the 3-hour limit.
Any further questions? Thank you, counsel.
Good morning, and may it please the court. I'm Assistant Butler County Attorney Brett Sweeney on behalf of the state. There's a 3-part test here that was laid out initially by the United States Supreme Court, Schmerber, in 1966. There's 3 factors. There's the exigency factor, there's the probable cause factor, and the reasonableness factor. The reasonableness factor has been conceded by the appellant at the lower levels already, so I will focus on the exigency and probable cause factors. I first want to address some of the questions I think it was Justice Lukert had with respect to whether or not this is an objective or a subjective standard as it relates to the officer and his understanding of what exigency is. Well, I think that's answered in Mitchell because in that case, that officer was operating under an implied consent statute. In that particular case, he arrested an individual. That individual passed out in the patrol car, became unconscious, and he did a warrantless blood draw, I think, at the hospital pursuant to that implied consent statute. So I'm not sure that that's something that ever went through the officer's head in Mitchell either, and that was the exigency was obviously upheld in Mitchell. So I think if we're looking for guidance as to whether it's a subjective versus objective standard, I certainly think the United States Supreme Court has said, well, it's objective.
So you're saying, when you say that doesn't matter, you're talking about whether the officer considers whether he or she can obtain a warrant. Is that
Yes,
what you're doing? All right.
Chief Justice, yes. And then I think there was some other questions with respect to whether or not the officer needed to settle for evidence from Justice McEnany and Justice Biles, I believe. And I think Justice Biles had a relevant point there. The state shouldn't have to settle for less evidence than they may initially have just to go ahead and get a warrant. I think it's also relevant that in this particular case, we don't, even if...
Isn't that always the nature of warrant jurisprudence, though? I mean, if the state has to get a warrant, it's going to take some amount of time. I mean, in many jurisdictions now it takes minutes.
I think that's correct, Your Honor, but I think it's also relevant in this particular case that, one, he did give an estimation of it might take 1.5 to 2 hours before I could obtain a warrant, but he'd also never obtained a warrant, so I'm not sure necessarily where that was coming from. But there's also the other relevant factors that this is an individual that was pretty severely injured. This is an individual that had to be transported out of Butler County and into a neighboring county of Sedgwick County because he had such a traumatic head injury. So even if he obtains a warrant within an hour to an hour and a half, I don't know that he's going to have a blood draw that means anything, because at that point you're probably looking at an individual that may or may not have additional drugs pumped into his system, and that's going to adulterate the blood draw.
Adulteration or contamination by that point. I understand that.
Yeah. And I think that the court in Mitchell did address that, and basically the quote that they had was, the time needed, quote, to secure a warrant may have shrunk, but it has not disappeared. Enforcing police to put off other urgent tasks for even a relatively short period of time may have terrible collateral costs. And I think that's something that we see in this particular case. So when Officer Ranger Burt arrives on scene, he's the first officer there and the only officer there. And for a matter of 20 minutes, 15 to 20 minutes, he's the only individual, whether it's law enforcement or emergency medical personnel, that is on scene. So not only is he trying to secure the scene, secure witnesses, talk to anybody who may have seen anything, but he's also administering medical aid to not only the victim in this case, but also the defendant, both of whom had some pretty severe injuries.
Well, would you agree that Mitchell
takes out of the equation the time it takes to get a warrant? Doesn't it shift the focus to the emergency circumstances that is confronting the officer, that creates the exigency, and the time to get a warrant is really irrelevant, isn't it?
I do, Your Honor. That appears to be the plurality opinion, that it basically eschews any time limits or any time requirements and kind of takes a look at any of the pressing needs that may be present in this particular case. And I think even if you did put a time limit on this particular case, I don't know that it would have mattered, because I think there's a possibility that even if he's able to get a warrant within 2 hours or even after.
Does it make a difference? Mr. Kittle made a lot of the fact that Officer Burt or Park Ranger Burt didn't even know a warrant was the farthest thing from his mind. Does that make a difference?
No, I don't think so, Justice. And I think the reason why is because I think it harkens back to that objective versus subjective standard. And I think in Mitchell, they were operating under the implied consent statute. And that appears to be one of the dissent's issues with that case, is that they ruled on an exigency ruling as opposed to just operating under what the officer was doing, which was operating under an implied consent exception. But the plurality in that case didn't seem to have an issue with it, and so I don't think it makes a difference how the subjective belief of the officer broke down there.
Counsel, the district court, as I read it, listed 4 factors under which it found probable cause. My first question to you is, did the district court cover all of them as far as you're concerned, or would you add others to what the district court said?
I think the district court did a pretty good job of covering them. I mean, I think I may expound on some of the things that the district court said.
Make the case for probable cause then, because I'm having trouble with it.
Yes, Your Honor.
Because basically all I think I can find is the smell of alcohol and some erratic driving, and erratic driving is not going to get you to much. I've got reasonable suspicion all day, but I'm having trouble getting to probable cause.
Yes, Your Honor. So I think, and the court mentioned it, but the first one is the odor of alcohol, and we know that he was in a good position, that being the Officer Burt, to know that it was a strong odor of alcohol, because in his testimony he said that he was actually checking the airways of the defendant.
But unlike the smell of marijuana, where marijuana is illegal, just drinking alcohol isn't illegal, and just drinking alcohol before you get behind a vehicle or get on a motorcycle isn't necessarily illegal. So how do you get to the fact that there's probable cause that a crime occurred?
And I would absolutely agree with that, but I think what it does is it moves the needle, and it's part of the calculus. And when we analyze probable cause, and I think the other factors that we would look at are, of course, the wreck. But I don't think it's just the wreck, because I think in many circumstances like this, we have a wreck, an officer comes onto the scene after it's already happened, and we have to use guesswork as to what may have caused this wreck. Did something run out into the roadway? Was another driver erring, causing this individual to run off the roadway? What happened? But in this particular instance, I think what we have is an eyewitness who can kind of describe the scene. We know what the location was like, where it happened, and pretty much exactly what happened.
Why does the party code give you probable cause that the people there are committing a crime?
Well, again, Your Honor, I don't know that in and of itself it gives probable cause, but I think it's part of the calculus. So, I guess I would liken it to if an officer sees an individual leave a drinking establishment or a bar, and immediately he sees or observes that individual exhibit some abnormal or unsafe driving behaviors.
But he wasn't, let's clarify, he wasn't leaving, he was coming upon the scene, correct?
Well, so he had been at that location.
But he didn't know that before. All he got was a description from the eyewitnesses about what happened. That other knowledge came in after all of this.
And I'd have to go back and check the record.
I think that's right. I think the only knowledge that he had was kind of what happened here, and the eyewitness said he was driving fast and lost control and slid into the parking lot.
Yes, Your Honor, and I think to what respects or how much he had been drinking, I think some of that is unknown. But I think given the fact that drinking in that area is rampant, just like a bar, and if somebody were to drive into an area, and I think that area is pretty small, and I think back to the...
Well, that's what I think Justice Biles and I are getting at. What is there a difference between driving to the Party Cove and driving to a shopping center and the same thing happening? I think the Court of Appeals said, yeah, there's littered with beer cans and all that kind of stuff. But does that factor into the equation as to whether there's probable cause?
I mean, to the extent that somebody that's heading to a bar or a Party Cove area is probably not looking to buy slacks, but maybe looking to drink or continue drinking, I think it's certainly something that is relevant and can be factored into, like I said, the calculus.
Because to me, that's the only difference you got here between just a wreck and odor of alcohol, is this Party Cove and the scene of where it took place. That seems to be a factor here that's pretty significant in this case. Because without that, I don't know that I would agree. You certainly have reasonable suspicion. I'm not sure you have probable cause.
Right. Well, with respect to that, and I think to touch back on the type of wreck that this was, the parking lot in question ends in a dead end. It's only 150 feet wide by 50 feet deep. And at the time that the officer arrives on scene after the accident, there's 15 to 20 people still there administering to the two victims in the case. So there's individuals that are just kind of littered throughout this party area. And this is an individual that drove this motorcycle at a speed of, the eyewitness estimated at 25 to 30 miles an hour. So certainly a high speed for a parking lot. I think what we have to say there as well, at that point we can tell that this isn't just your run-of-the-mill wreck. We know that there was a disregard for safety here, and that I think heightens this wreck to something that's like a super wreck or something, but it heightens what we know about probable cause, and I think moves us farther down the road as far as that probable cause.
A disregard for safety because there's people in the parking lot milling about, that whole kind of...
I think so, Your Honor, as opposed to something where it's very possible that it just could have been two drivers on the road and one of them erred and something happened. We don't know if it lends any credence to whether he was intoxicated or not, but in this particular instance, I think it does. So I think the wreck, the type of wreck that it was, the smell of alcohol, and then having that corroborated by the eyewitness, I think that's what the state would lean on to support probable cause.
We don't know. It seems to me that the mechanism of the accident itself is significant, and we apparently know nothing more than he lost control. Is that correct? We don't know what caused him to lose control, whether he was putting the bike down in order to avoid something in his path, whether he simply just fell off the bike and the bike careened over on its side and slid. Do we know any of those details?
Yes, Your Honor. So what we do know is that the road into this parking lot was paved. There were some questions asked to the officer in this case regarding potholes or any any problems with the road, and he testified that there wasn't. There was the eyewitness who I think made a statement to the effect of like, oh, I don't know if he's coming in pretty fast. I don't know if that looks like it might be trouble, essentially. And then the officer did do a measurement on when the bike was laid down, and it traveled 106 feet through the parking lot before it eventually flew into the victim in this case and pinned her against another truck. So I don't know that we know much more beyond that, beyond excessive speed and just kind of an area where it shouldn't be. But there's no indication, I don't think, that there was any potholes or anything that would have caused this beyond his own misjudgment of the roadway and inappropriate driving behavior.
And what did the evidence show about where he came off the bike?
It shows that he came off the bike and he basically did not travel any further than that. The bike itself came out, I guess, probably from under him and traveled 106 feet through the parking lot until it slammed into the victim hard enough to do some pretty serious damage, and it pinned her against the vehicle.
Okay, thank you.
If I may briefly just go back to the exigency issue quickly, I think where we're at on that is Mitchell, I think, carved out almost a per se exigency for individuals who are unconscious. But I think in this particular case, what we have is kind of Schmerber, which is an accident. That was the exigency that put that case over the top. But we also have the unconsciousness that you have in Mitchell. So I think our case is essentially Schmerber plus Mitchell plus some additional facts. And then one final point that I'd like to make I know I'm kind of jumping around, with respect to the probable cause, is that I think our case comparably matches up pretty well with the Schmerber versus California case. In that case, it was also an accident. The officer smelled the odor of alcohol, and I think he also observed some watery eyes. But I think comparing the two cases, and of course that was held up on the 3-part test, that part of it was probable cause. So I think comparing those two cases, we match up pretty well with the probable cause.
The distinction with Schmerber is that the time of the warrant was a factor to be considered in the exigency, and here maybe it is, maybe it isn't, but it seems like it's not.
Exactly.
Yeah. What should we do here if we think Mitchell applies? Should we apply it, or should that be remanded back for you all or whoever's there to apply Mitchell at the district court and argue that the facts under Mitchell apply?
Your Honor, I would tell you that this case, and I think my opposing counsel has already mentioned it, but it was reversed and remanded on another issue.
It's going back anyway, right?
Well, right. I agree, and I think he's already served all of his time anyway. I think he's on post-release supervision at this point, so I think it may be a moot issue.
You're not arguing it's that's an inside joke.
Yeah.
Anyway,
Here we go.
it is going back anyway. We can discuss that. I'm just wondering what's the appropriate forum for Mitchell to be applied. Is it here, or is it back at the district court when it goes back?
I think it probably is back at the district court when it goes back. That's all I have, unless there are any further questions for me. That concludes my presentation.
I wanted to go back to the issue of objective versus not objective. And I was looking at what the court said in Mitchell, and they're quoting Schmerber. It starts by saying, "We held there that there was no time to secure a warrant before a blood test for a drunk driving suspect in Schmerber because the officer there could, quote, reasonably have believed that he was confronted with an emergency in which the delay necessary to obtain a warrant under the circumstances threatened the destruction of evidence," unquote. So what is your take on what that language means?
And again, I think this is where I would go back to Justice Rosen's point about Mitchell, where it revisits Schmerber. And I think basically what it does is it wipes out those time requirements. And I think I mentioned that even with those time requirements, I don't know that with the pressing needs of the officer in this particular case, that he would have had the ability to get a warrant for blood draw that would have given any evidentiary value. But I think in Mitchell, reading Mitchell, I don't know that it matters anymore, because it seems to have abolished that time requirement as it relates to at least to individuals in this particular circumstance.
So there's no need for the officer, in your view, based on Mitchell, to consider whether to apply for a warrant. You just say, here's the situation, I'm going to have a blood draw.
Objectively, if the facts later warrant an exigency, no.
All right. Any further questions?
One quick question. Is there going to be a new trial in this case?
No, Your Honor.
How is it not the case that you are just asking for an advisory opinion?
Well, Your Honor, I can tell the court that he's already maxed out his sentence in this case.
His conviction was reversed,
Right.
and you're here representing the state saying there's no new trial. And now I'm left wondering how this is all not, I mean, we joked about, the mootness joke was made, but how is this not a request for an advisory opinion?
Well, and I guess it might be. That's given the fact that he's already served a sentence. I think we'd probably have to take a look at the resources that we have available to us and whether it would be warranted to retry this
Well,
case.
you just said there's not going to be a retrial.
I wouldn't think so. No.
Okay.
Thank you, Justice. With that, I don't have anything further.
All right, thank you, counsel.
Counsel, can I just start right back with the same question? Your client has won a reversal of the conviction,
Correct.
and the state's represented there's not going to be a trial. How is this not just
Well,
a request for an
I
advisory?
didn't know that at the time that I filed my petition for review. I'm learning about that right now. We got a reversal of conviction, but what I was fearing was if we didn't petition, he would be sent back to the district court and we'd end up here and the state would have dotted all the I's and crossed the T's and he would stand convicted again. So, and I wanted to have this suppression issue litigated if possible at the appellate level.
So there is your response that despite the state's representation here, that it's still legally possible, at least, that he might be retried?
Let me answer that this way. I don't think I could advise my client that it's a sure thing that he won't go back to the district court and not get reprosecuted. I don't know.
Well, what about this representation? We have the prosecutor from that jurisdiction saying there's not going to be a retrial.
Well, I'm happy to hear that, but I'm not. I can't advise my client. in that
No, I
case.
understand that, but it seems okay.
I'm not going to give up on Mitchell v. Wisconsin either. I think that one of the things that's said in Mitchell, as I indicated earlier, is that under the exigent circumstances exception, there has to be a compelling need for official action and no time to secure a warrant. So I don't think the time exigency is completely gone, even after Mitchell v. Wisconsin. I think what the state is trying to...
In the conclusion, the very last sentence or two of Mitchell, what the plurality says is they define what is perhaps that unusual case. And they don't seem to put time into that factor as what would be that unusual case. So what do we take from that? I mean, they mentioned that his blood would not have been drawn if police had not been seeking BAC information, and that police could not have reasonably judged that a warrant application would interfere with other pressing needs or duties. Those seem to be the two exceptions they draw.
I would just say I don't know that you can reliably rely on that because of something that is not stated.
Then let me ask it this way: how is your argument different than Justice Sotomayor's dissent?
I guess my argument is different in the sense that we have peculiar facts in this case where the officer is conceding that he never even considered a warrant. Now, I realize the court has brought up the point that, well, maybe it doesn't matter what the officer was thinking, but in the example that the Chief Justice just gave, they talked about how the officer reasonably believed that he needed to immediately obtain evidence lest it dissipate. There's no way, based upon Burt's testimony in this case, that he could have reasonably believed that he needed to act right then, because he testified himself he had time to act, and he testified that he wasn't even considering these things in the first place. So I think all of that brings this court this case out from under the application of Mitchell v. Wisconsin. And my time's up, so what I would ask, unless the court asks questions, what I would ask for is a reversal of Mr. Chavez Major's conviction, and if the case should go back to the district court, that it go back with an order that the evidence in question here be suppressed.
Any more questions?
Would it be up for us to apply Mitchell, or should we, when it gets remanded back, for it to be taken up there where it can be argued and facts applied, or
I think this court is in good a position to assess that as the district court is, so I think this court should make that decision.
So, Mitchell Supreme Court Mitchell remanded.
Right.
And what distinguishes this from the Supreme Court?
Well, I don't know how to answer that. Maybe there is nothing to distinguish it. My argument is that Mitchell doesn't apply here, so.
Right. Okay.
Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. This time the court stands in recess for 15 minutes.
All right.